I was saying good afternoon to everybody, and thank you so much for joining us today for our webinar about OFPs, HROs, and DANCOs. My name is Ana Maria Studer, Advocacy Support Program Manager here at Standpoint, and my role today is to help facilitate the webinar. If you have any questions during the presentation, please type your question in the Q&A tab, or you can use the chat box, and I will pass the question along. Most of you probably already know about our organization already, but for those that listen to this later or those that don't know, Standpoint is a statewide organization, and we are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors, and we do this by facilitating trainings and answering calls through our action line. Example of the trainings that we do are the annual new laws trainings throughout the state of Minnesota, the monthly webinars for advocates like the one we're giving up today, and other trainings by request. Our action line is answered Monday to Friday from 9 a.m. to 4 p.m. And it is through our action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources, safety plan, listen, and help callers identify possible options and next steps. This webinar is being recorded, and you can check it out on Standpoint YouTube page. The link will be emailed out to Standpoint Legal Advocates listserv after the webinar. And our presenter today is Rana Alexander, our Executive Director. She has worked in the domestic and sexual violence field since 1997. Ms. Alexander joined Standpoint, formerly known as Battered Women's Legal Advocacy Project, in 2005, and she became the Executive Director in 2016. As an attorney for the statewide organization, she provides legal advice and consultation to domestic and sexual violence victims, advocates, and attorneys on legal issues that affect domestic and sexual violence victims. And she also provides training and outreach to attorneys involving issues of domestic and sexual violence and the law. Ms. Alexander is a graduate of Northeastern University School of Law in Boston, Massachusetts, and she received with distinction her Bachelor's of Science degree in psychology and a minor in women's study from Iowa State University. And I have my pleasure to introduce Rana Alexander on this amazing webinar about OFPs, HROs, and DANCOs that are so important to the work that we do. Thank you, Rana.
Thank you, Ana Maria. Today I'm going to talk about orders of protection, harassment, restraining orders, and DANCOs. It's going to be a high-level discussion and some information about filing and what to put into petitions, etc. There will be another webinar later this year about kind of answering more kind of the specifics and answering a lot of the questions that we get on the phone. And I believe Ana Maria and Maddie, who is another advocate with us, and I believe Eileen will be leading that webinar. But this one's going to be a little, it's going to be more high on the high end. I'm all very right, but we'll figure it out. It's going to be fine. All right. So let's start. We're going to talk about in Minnesota how we have 3 different types of protective orders. So we have orders for protection, otherwise known as OFPs, and those are in Chapter 518B, and they are for folks who have experienced domestic abuse as defined in the statute. And you have to have a family or household relationship with the person who is committing the domestic abuse. And again, that's got a specific definition. There are also harassment restraining orders, often called HROs, or in Hennepin County, for reasons I've never understood, HAs. I don't know what the A stands for, but there it is. So that is under statute 609.748, and it applies in cases where there is harassment as defined, and you do not need any particular type of relationship. You can get a harassment restraining order against anybody. And then finally, also kind of under the idea of protective orders is a domestic abuse no contact order or a DANCO. And that is found in chapter 629.75. And those are issued in criminal cases. So we will talk more about that. But first, we're going to talk about the generics of orders for protection. When are they used, and the statutes and the case law that help us broad-basely understand orders for protection. All right, so the first question is, what is domestic abuse? So the Order for Protection statute defines domestic abuse as 6 things. It used to be 5 things until 2 years ago, and we added sextortion, which now makes it 6 things. It screws with my jazz hands, and now I get a jazz hand and a jazz thumb, I guess is what happened here. But now it is 6 things, and it is physical harm, bodily injury, or assault, creating fear of imminent physical harm, bodily injury, or assault in another person, criminal sexual conduct, 1st through the 5th degrees, terroristic threats, also known as threats of violence, sexual extortion, which is something that was just added in the last couple of years, and then finally interference with an emergency call. Well, depending on how we want to. Sextortion, sexual extortion is something that is added and is a newer crime in Minnesota. And just for folks to know that that's talking about when, basically when you ask somebody, you say, if you do this for me, if you have sex with me, I'll do this thing for you. So, or I won't do this thing. So if you have sex with me, I won't harm your business, trade, or profession. If you have sex with me, I'll make sure you get to keep your job. If you have sex with me, I won't evict you, or I'll waive your your rent for this month. So it's this idea of saying, have sex with me, and I either won't or I will do something for you, and it's something that you need. So that's sexual extortion, and A, it's a crime now in Minnesota, and B, it's also a reason to get it's now defined as domestic abuse. And I also always like to remind people when talking about interference with an emergency call, we often shorten that when we talk about it. We say interference with a 911 call, but in fact, the language is emergency, and it's important because it is not just simply calling 911 that qualifies as the crime of interfering with an emergency call. The way the language is written is actually anytime you're in an emergency and you are calling somebody. So arguably, it could be calling your mom and saying, oh my goodness, I need you to get over here, something really bad is happening, and that call is interfered with. So just keeping in mind, it's a broader definition than simply a 911 call. So it could be other types of emergency. All right, so when you're thinking about getting an order for protection, you got to show 1, there's been domestic abuse. So one of these 6 things, you got to be able to show the court that there's been domestic abuse. And then you got to show that there's a family and household member relationship. And that's defined under Minnesota statute. And it includes spouses and former spouses, parents and kids, blood relatives, used or used to live in the same house together. And we have law that verifies that, in fact, that's what our statute says. I have seen this be used in not just roommate situations, not just significant others who may not be married situations, but I've also seen it used in prisons with your same cellmate, because you live or used to live in the same house together. But where it does not apply is when you have people who live in the same apartment building together, but they live in separate apartments, right? So somebody lives in 1A and somebody else lives in 1B. That is not living or used to live in the same house together. If you are renting a room in a house and you are sharing other facilities, you're sharing bathrooms, or you're sharing a kitchen, or you're sharing other things, that would also be considered living in the same house together. But living in the same apartment building, that does not count. If you live in a house that has separate apartments, like they cut it up, and that would also not count in this circumstance. You have a child with the other person, you may have a pregnancy in common, or the last one in Minnesota is a current or former dating partners in a significant romantic or sexual relationship. And statute tells us that the court should consider the length of time of the relationship, the type of relationship, the frequency of the interaction, and if the relationship is terminated, how long since the termination. We have case law that clearly says that significant modifies both romantic and sexual. So it's a significant romantic or significant sexual relationship. And that the court's supposed to look at that on a case-by-case basis. But the courts have been really clear, our appellate courts have been really clear, is that you do not need to stay in a relationship just simply to be able to get an order for protection. Get out, get safe, and then if you need to seek that order, do that later. Or if somebody, you are in a relationship and you get out and they continue to engage in acts of domestic abuse, you can still seek an order for protection. So the court's been really clear. You don't have to stay in your relationship to be able to get an order for protection. Minnesota's definition of family and household member is a very broad definition, covers an awful lot of folks, really covers a number of folks across a variety of different types of intimate relationships or family relationships. The big one that it does not cover in general is in-laws, specifically mother-in-law, but it doesn't cover in-laws unless you meet one of these other qualifications, because your in-laws aren't your blood relatives. I mean, maybe you were married to an in-law, then you would have that parents, but you would have that spouse relationship. But in-laws in general are not covered. But otherwise, all the other kind of folks that in general we encounter as family or household members are covered under this statute. So Minnesota's got a nice broad statute. All right, so get an order of protection. You got to show domestic abuse has occurred, and you got to show that that domestic abuse was committed against the petitioner by a family or household member, right? Those are the big, broad things you got to show. So the next question is, so I got my domestic abuse has occurred by a family or household member. Can I file in Minnesota? So per our statute, Minnesota does not have any residency requirements, which means that you don't have to live in Minnesota for a certain amount of time. If, say, you're fleeing domestic violence, you're working with somebody who is fleeing domestic violence and they flee from Texas and they come to Minnesota, they don't have to be in Minnesota for a certain amount of time before they can seek an order for protection. They can literally land in an airplane here in Minnesota and go to court and immediately apply for an order for protection. They do need to be planning on making Minnesota their home. So they can't fly from Texas, land in Minnesota, get an order for protection, and move back right away back to Texas, right? So they need to be making Minnesota their home, but they don't have to be here for a certain amount of time before they can apply. The respondent does not need to live in Minnesota. But you do need to show that there is sufficient connection to Minnesota. So that's going to be that the petitioner is in fear in Minnesota and the respondent has had some sort of contacts in Minnesota. We have case law around that called Hughes v. Cole. And depending on the circumstances, that fear may be enough. It's going to depend on some things. You don't have to have the respondent actually live in Minnesota to be able to get an order for protection against the respondent. Which county do you file in, otherwise known as venue? According to our statute, you can file wherever the petitioner or the respondent reside. And again, that's where they desire to make a permanent home. So if somebody has fled to shelter, say up, they were living in Hennepin, but now they're in shelter up in Polk County, they can seek that order for protection up in Polk County. They don't have to come back to Hennepin County. So where they desire to make a permanent home. Or they can file where the abuse occurred, or they can file where there is another family court proceeding that has occurred with that abuser, with the respondent. I often get asked, can they file where they work, the county they work in? And the answer is only if that is where they reside, the respondent resides there, or the abuse occurred there, or if there is another family court proceeding there. Simply because you work in one county does not give that county venue for filing an order for protection. So who can file for an order for protection? Any adult victim of domestic abuse against a family or household member. A minor who is 16 or older can file against their spouse or former spouse or a person with whom they share a child. Otherwise, all other minors have to have a parent, relative, a guardian, or a reputable adult aged 25 and older to file on the minor's behalf, right? So if you're working with somebody who is under the age of 18 and they would like to seek an order for protection, they're going to need somebody else to file on their behalf. All right. I'm seeing a lot of things happening in the chat, but I'm not sure if it's anything I need to pay attention to. So I'm going to assume Anna Maria will interrupt me if you need to.
We were just having some issues with the Dropbox. Some folks weren't able to access it, so we've got that figured out.
Okay, great, perfect. Somebody is asking if the statute defines reputable. It does not. And to be fair, no idea how the court would know. But it does not define that. Basically anybody, unless somebody raised the issue of saying, well, that person's not reputable. So good question. So in Minnesota, we have a couple of different types of orders for protection. Sorry, Anna Maria is asking, can the respondent be a minor? And yes, absolutely, the respondent can be a minor. Technically a parent can file against their minor child. The thing is that the parent will need to have an answer on what's going to happen with that minor child. Where are they going to live if they are living currently with the petitioner? But again, or wanting to remind folks, when you get these more complicated, more unusual type situations, you can certainly give Standpoint a call, and we're happy to talk to you about any of those types of things. Yes, absolutely. The respondent can be a minor, and the petitioner could be a minor. We could have a dating violence situation going on. February is Teen Dating Violence Awareness Month. So when you file for an order of protection, the first order that one would get normally, there are exceptions to this, but the first one would get is called an ex parte order. An ex parte is Latin, and it means one party without notice to the other party. And when so what happens is an ex parte order for protection is extraordinary relief. It's a really big deal in the courts in general. We don't like to grant relief without both parties being present and being able to provide information to the court about what should happen. But in this extraordinary circumstance where we have somebody who is in fear of domestic abuse happening, and they're concerned for their safety, we have this extraordinary relief called this order for protection. And we allow in these circumstances somebody to petition for an order without notice to the other party. We allow the court to grant relief for a short period of time to be able to make sure that that person is safe, or the idea is to help them be safe before we have a hearing on the order. So because of that extraordinariness of an ex parte order, you have to allege an immediate and present danger of domestic abuse. Okay, so you got to show that immediate and present danger. One of the interesting things about Minnesota that is not true in some other states is that ex parte order could become final if neither party requests a hearing. And if only specific type of relief is requested. I often refer to that as sub 7 relief. We'll talk about that in a little bit. So you could end up with a final order without a hearing if that specific relief is requested and then nobody asks for a hearing. Okay, so you have this ex parte order that you get immediate and present danger of domestic abuse. And then if there's a hearing that's requested or one is required, then we would move to what I call a final order. There isn't a very good term for it. That's what I come up with. And that can occur either after an agreement or after an evidentiary hearing, or If there was never a hearing scheduled and no one asked for one, it becomes a final order. What kind of relief can you get in an ex parte order for protection? You can get the respondent to be ordered not to commit further acts of domestic abuse, to exclude the respondent from the residence, and I have Swanson v. Swanson in here because the petitioner cannot be excluded from the home. You can exclude the respondent from a reasonable area around the house. And State v. Anderson says you need to specify the area of exclusions. You need to be clear about what is that reasonable, what's that area around the house. You can exclude the respondent from a workplace or limit access to a place of employment. Order the respondent to not contact the petitioner, which can include by phone, telephone, letter, third party, electronic means, etc. You can award, modify, return custody of children or a child. That will require a hearing though, but it is relief that can be granted ex parte. Care, possession, or control of a pet or companion animal. Prevent the respondent from abusing or injuring any pet or companion animal. Order the respondent not to make any changes in insurance or dependent insurance coverage. Ask for the return of house or car keys. Ask the sheriff to recover those keys when the OFP is served. Asking the sheriff or other law enforcement to go with the petitioner to the house to either remove the respondent or to recover property if the petitioner does not want to return to the house, but still does not want to return to the shared property, but still wants their stuff. And order the respondent only to remove property with the help of law enforcement present. So that's the relief that one can get ex parte. It is that specific relief that can be requested that would not necessarily trigger a hearing. Additional relief that one can get after a hearing is restitution for expenses relating to the abuse, establishing or modifying a parenting time schedule. Do you remember that in Beardsley v. Garcia that a father who's only signed a recognition of parentage can be awarded temporary parenting time in an order for protection? You can ask the court to order supervised parenting time. Child support can be ordered. Spousal maintenance can be ordered. Who gets use of property that they have in common, such as a car? I always counsel people to be very careful and thoughtful about when you're using this piece about what property. It needs to be something really important. Like, I need this car so I can get to work. I need the laptop so that I can work. Are you putting in there that somebody needs a TV or a couch? That's just going to irritate the court right quick. So these are things that you need to be able to sustain yourself, to like live. You got to work. There's something that you really need to take care of a child. Those types of things. Try to stay away from furniture. And while those are important, and I'm not trying to minimize them, it's not something the court is going to want to get involved in a emergency type proceeding. You can order either party to sell property, damage property, use it for a loan, order the abuser to complete counseling or treatment, or order any other relief necessary for the protection from the abuse. So the order for protection statute allows for a very broad anything that could be helpful to the petitioner or the petitioner's children to help them be protected from abuse. Great things to think about that go there. If you have somebody who is in public housing or is Section 8 and they receive a housing voucher, you can have the court order the voucher to the petitioner. If there is a court order ordering the distribution of the voucher, public housing will abide by that. So the housing authority will abide by that court order. So another great one is the return of documentation like Social Security cards, visas if somebody is an immigrant, passports, birth certificates. If somebody is holding your legal documents, it is a good way to ask for those types of things to be returned. Daycare. Stay away from daycare often gets added in here, or stay away from a school if the petitioner is still is in school. So again, what is needed to help protect somebody from the abuse? And then finally, after a hearing, firearm prohibitions attach. So you got to have a hearing for firearm prohibitions to attach.
There is a question about, does the order become legal upon it being served? Meaning if somebody expects it coming and they avoid law enforcement, the order can't be yet enforced?
So correct, the order cannot be enforced until, well, so that's a complicated question, because basically what the law requires for a violation is that, and this isn't really, I'm not training on violations today, but what the law requires for a violation is that the respondent knows of the order. And so if there is proof that the respondent knows of the order, and sometimes we have that, like there's a text message saying, I know you got that order for protection against me and I'm just not going to get served. Okay. Well, A, that's a violation of the order, and B, I got proof you know about it. Some prosecutors in Minnesota are happy to charge those types of violations. Others feel that they need actual service to occur. Service is just the best and easiest way to prove somebody knew about the order. However, if they don't know about it, or you don't have any proof they know about it, services, that's the way you're going to have to show that they knew that the order existed. The order itself is valid, it's just not enforceable.
Another question, Rena, it's sometimes we have calls about people that want to file an order and they want to ask for mental health evaluations or clinical dependency evaluations on the order.
Mm-hmm. I mean, you can ask for that and the court can order it. I don't know who enforces it.
Mm-hmm.
I mean, that's the problem. It's a civil order. It's going to be upon the petitioner to have to enforce whether or not the respondent actually did that thing that was ordered of them. It may work better. That happens better in a family court setting if there's a divorce or custody action occurring. But you can certainly ask for it and the court can certainly order it. It's just really the problem of how do you know whether it occurred or not? And then if they don't, what's your solution? Contempt is the only enforcement mechanism in this part of an order of protection. And I mean, technically it would be a criminal violation. I'm not really sure whether a prosecutor is going to be willing to charge out that as a criminal violation that somebody did not seek a mental health evaluation. So then you're looking at contempt, and is that really, so yes, it's there and you can ask for it and the court might order it. It just becomes an issue of enforcement.
And then Melissa wrote down, do you have any suggestions for officers who don't read or don't want to enforce the relief section before or during service? I had to argue with an officer for close to 2 hours about why petitioner needed her vehicle with the car seats to transport kids to school and daycare, and respondent had several muscle cars to choose from for personal transport, but just had to take mom's car. I roll.
I mean, I guess the question is did she have keys? Could she just take it herself? So, I mean, she has an order. If there is a court order giving her the car, then she could take it. So if that might be an option, I think that's an excellent time to call Standpoint and have a conversation. There's a lot of thought process that needs to go into that. It's hard to just answer in the middle of a webinar. So please give us a call and we'll happily workshop that with you.
And another one, Dawn, is following the Fifth Circuit Court of Appeal decision early this month on DV restraining orders. Do you see this causing any problem in Minnesota as related to firearms?
Not right now. The Fifth Circuit, we're in the Eighth Circuit, and the Fifth Circuit decision does not affect Minnesota. And we will let you guys know if it ever is, if and when it affects Minnesota. But at this point, it has no effect on Minnesota. All right, great questions. Okay. So what do you file when you are filing for an order for protection? You want to file the petition and the affidavit for ex parte relief. I'd like to remind folks that you do not need the respondent's address to be able to issue an order for protection or a harassment restraining order. If for some reason you're receiving pushback from either your court administration or your bench, let us know. There's actually a memoranda that went out a number of years ago on this issue that we can get to you. You want to file the petitioner's information sheet and the law enforcement sheets. Those are the documents that would get filed. How do you do that? You file the petition, the affidavit, and other paperwork in every other county but Hennepin. You either present it to court administration or you could use guide and file for sure. And a lot of folks are doing that, especially now since the pandemic. Those documents are then given to the judge, and if signed, it's given to law enforcement for service. If we're in Hennepin County, then there's a different process. You're either faxing it to the family court or you're going through the Domestic Abuse Service Center, and then they take care of it. So there's just a different process in Hennepin County. For court fees, orders for protection there are no court fees for the petitioner or the respondent. So those are waived, and that's actually because of federal law that requires us to waive. Orders for protection have some pretty strict timelines around service and hearing. So if an ex parte order is not issued, a hearing has to be scheduled in 14 days. And so the court's been moving more towards this scheduling a hearing that's called first at many communities like the initial hearing or the admit deny hearing. And that's where the respondent may either accept the issuance of the order or accept the order but without findings of domestic abuse, or ask for an evidentiary hearing. And then the court is scheduling later, days, weeks later, the evidentiary hearing. But what our statute requires is that there's at least a hearing scheduled within 14 days if the ex parte is not issued. If the ex parte is issued and only limited relief, so that sub 7 relief is requested, no hearing is required, and then the respondent has 5 days from service to ask for a hearing. If the respondent asks for a hearing, then then there has to be a hearing within 10 days after the request. If there is no personal service within 14 days of the ex parte, it will expire. And so it is really important that somebody, whether that's you as the advocate or the victim, or the petitioner, is keeping track of if service has occurred, because if it has not occurred within 14 days, that order expires. And so that means one has to ask for service by alternative means or by publication before those 14 days expire. If the ex parte order is issued and somebody is asking for additional relief, there has to be that hearing in 7 days. Right. And again, a lot of communities are doing that in that admit deny as your first hearing, and then the evidentiary hearing being set later. Service by alternative means means either A, alternative means, which orders for protection are actually a family court order, which doesn't mean a whole lot to most folks when you were outside of Hennepin and Ramsey, and when your family court is the same as your criminal court, is the same as your housing court, is the same as your regular civil court. But it does mean the rules of family court apply to orders for protection. And the rules of family court allow for service by alternative means, which involves, instead of having to do publication in a newspaper, there's a mailing process that is done. And it's much cheaper and much faster, and actually much more likely to give notice to the respondent. So it can happen either by alternative means, or it can happen by publication. If you're going down the publication road, one has to show that service is unsuccessful because the respondent is avoiding service by concealment or otherwise. That's one in the statute, that's the language, and B, we have the Aaliyah case that says, yeah, you have to actually show that because that's what's in the statute. And then the statute also requires that it might reasonably succeed in notifying the respondent. So most folks go down the alternative means unless there really is no idea on where the respondent might possibly be at this point. All right, so we've filled out our documents, we've filed them, and now we're the court's looking at them, trying to decide whether they're going to grant this ex parte order. What is the court looking at? What's the court trying to figure out? So the standard the court is going to apply in an ex parte order for protection is, did domestic abuse occur against the petitioner by a family or household member, right? And is that respondent a family or household member? And we have to remember, this is even true if you're filing an order for protection on behalf of another person. So a minor or another adult for some reason, that there would be a lot of stuff that goes into that. But so it's even true if you're filing on behalf of a child. That child has to have experienced domestic abuse by a family or household member. Otherwise, the relief is not available of getting the order for protection on behalf of the child. The relief is still available for custody or parenting time or supervised parenting time. That relief still exists, but you wouldn't be able to get the order on behalf of the child. And that comes from the Schmidt v. Coons case. You gotta show domestic abuse occurred. You need to show, per the statute, there is an immediate and present danger of domestic abuse. So your petition needs to help the court understand why today, why are we scared today that domestic abuse is going to occur? If you want the ex parte order. Don't need an overt act. Fear and is enough based on understanding the totality of the circumstances, which can include that past abusive behavior. And while there is no temporal restriction on when physical harm occurred, so physical harm could have occurred 7 years ago, I think is what it was 6 or 7 years ago in the Thompson case. You still, to be able to get the ex parte, need to show there is an immediate and present danger of domestic abuse. So why today? Why are we scared today that something bad is going to happen? Even though the physical abuse might have been a long time ago, we're in fear today. Why? So that's the standard the court's applying when they're looking at issuing the ex parte order. If there's been a hearing, after the hearing, what is the standard the court is looking at applying? Well, first of all, did domestic abuse occur against the petitioner by a family or household member? The court is looking to determine whether domestic abuse occurred by the preponderance of the evidence. And that's a civil standard, which like civil law professors will get mad at me when I say this, but it's something like 50.1%, right? Is it more likely than not that the domestic abuse occurred? And then 2, so the court is looking and saying, did domestic abuse occur? And then the second thing is, should I grant this order for protection? And the court's going to look at relevant circumstances of the domestic abuse, including the timing, the frequency, the severity, and the likelihood of future abuse. All right, so the court could say, yeah, domestic abuse occurred here after a hearing. For sure, I believe you, it happened. But I'm not going to grant this order because, and then list reasonings behind why it may not be granting this order. That's what the Thompson case says that the court can do. But most of the time when the court finds domestic abuse, it's willing to grant that order after a hearing. All right, orders for protection in general last 2 years. The statute does say it can be longer or shorter as the court deems appropriate. So, depending on your circumstances, I've definitely known folks who have gotten orders for protection that have been granted for 5 years right at the onset, 10 years, because of the abuse was so horrific or what happened to them was so significant. And there were also, in those cases, often criminal charges that were pending of a pretty horrific sort. And the court was happy to grant a long order for protection. And at the same time, I hear of courts every now and then who are issuing orders for shorter than 2 years, 6 months, 3 months, a year. That's up to the court to decide. And then finally, and we'll talk about this later in the presentation when I get to extensions, but the court can also issue a 50-year order for protection. And we'll talk about what that means when we talk about extending an order. That's where the 50 years comes in. Can a non-custodial parent get rights through an order for protection? Yep, absolutely they can. That's they can get parenting time through an order for protection. That's what the Schmidt v. Coons, no, that was nope, that was Beardsley told us that father who has only signed a recognition of parentage, but there aren't any other court orders, can get parenting time through an order for protection. All right. That's our first high-level part of orders for protection. We're going to move on to harassment restraining orders now. So harassment restraining orders. So to get a harassment restraining order, you need to show that there has been harassment that has occurred. And under Minnesota statute, that is a single incident of physical or sexual assault. Repeated incidences, which case law tells us is 2 or more, of intrusive acts, words, or gestures that have a substantial adverse effect or intended to have a substantial adverse effect on the safety, security, or privacy of another. The Borth case from last year tells us very clearly that substantial adverse effect is only required when somebody is petitioning for a harassment restraining order based on repeated incidences. So if somebody is showing they were physically assaulted or sexually assaulted, they do not need to show, in addition, that that's had a substantial adverse effect on them. It's only if they're seeking it under repeated incidences. Your mileage may vary in how your judge feels about that. In case law, it says that that's the only place that needs to be shown. It might always be worth your time just to, the reason somebody's seeking an order is because it's having an effect on their safety, security, or privacy. So it's probably always good to just have the person talk about how it's affecting you. A single incident of non-consensual dissemination of private sexual images. Folks may often refer to that as revenge porn. Trying to move away from that language, but just so that you know. A single incident of using another's personal information without consent to invite, encourage, or solicit a third party to engage in a sex act with a person. This is a crime in Minnesota. I often refer to it as the Jenny crime, the Jenny law, which is in reference to Tommy Two Tone's song 8675309, because essentially that's what he's doing. He's violating this law. He's putting her phone number on the wall and saying for a good time call, which is inviting somebody without their consent to engage in a sex act with the person. But this is, all joking aside, this is very serious. People have had very horrific things that have happened to them where their abusive partners have said, post something on Craigslist saying, come over to my house, have sex with me. And it's without the petitioner's consent. So that's a reason to get a harassment restraining order. And then the last 2 things that I have in smaller type, and really because for our purposes as domestic and sexual violence advocates, we don't see this a whole ton, but it is in the statute, and I like folks to be knowledgeable about it, is targeted residential picketing or a pattern of attending public events after being notified that the presence at the event is harassing. And so the pattern, the residential picketing is actually related to picketing that was happening more in the 90s in Minnesota of doctors who performed abortions. And then attending public events was also related to abortion activist or anti-abortion activist activities. So you got to show harassment occurred. One of these things needs to occur. And then the respondent can be anybody. It can be by anyone to anyone, regardless of the relationship between the actor and the intended target. So anybody can get an order against another person. The relief available in a harassment restraining order is significantly narrow compared to an order for protection, where there is very broad relief. A harassment restraining order statutorily only says that the relief available is to cease or avoid harassment or to have no contact. Another case called Williams v. Reamer, which happens to be unpublished, but is a case that has been applied, has said that exclusion out of an area, so having excluding somebody away from a home, like a radius around the home, that's part of not having contact. And so the court has upheld that. But do keep in mind the relief available is, per the statute, is no harassment, no contact. So it is not an order that's meant to have very broad relief like the order for protection. Can you file in Minnesota? Statute tells us that you can file where the petitioner or the respondent reside. And again, that's where somebody desires to make a permanent home or where the harassment occurred, right? So similar to the order for protection and where you can file. And then who can file for a harassment restraining order? The victim of harassment can file. That includes businesses, and that's the Dayton-Hudson case that tells us that from '95 that says a business can file. A business can file for the order for protection. Technically, the business could be a respondent. That's a little more complicated, but could be. And businesses include churches. They include domestic and sexual violence organizations have had to file harassment restraining orders at times. So it's not just the individual. It also can include an adult who is under guardianship. But the Gellerman case tells us very clearly that that cannot violate the Bill of Rights of the person subject to guardianship, which means if the person subject to guardianship is objecting and does not want the harassment restraining order, the court is supposed to consider that pretty seriously. And then if you have a minor, a parent, a guardian, or a step parent can file. And it's very specific on those three people, and we have case law that says you got to be a parent, a guardian, or a step parent to be able to file on behalf of a minor. Last year, there was statute, the harassment restraining order statute was modified to also include emancipated minors if it's in their best interest. Now, it's a little complicated because Minnesota doesn't actually have an emancipation law. And so the statute goes on to, the amended part of the statute goes on to say that a minor can show that they are emancipated by showing the court that they are living separate and apart from their parents. They are managing their own financial affairs. And they also have to show that all parents have relinquished control and authority over the minor, either by writing or by their conduct. So there is this option that might exist for some minors who are living on their own away from their parents. If you've got more questions around this, or you're working with somebody and you're thinking this might be an option for them, give Standpoint a call because this is all very new and we're all still trying to figure out exactly how this works. So I don't have any other great information for you beyond what I literally just told you because it's so new and we're not sure how it's going to work. What do you, Anna Maria asked, what about if the minor has a child? As for, can they file the HRO on their own behalf?
Yes, can they file on their own behalf?
They cannot. Just because one has, you still have to file the emancipated minor statute part. We don't have that same language that the order for protection statute has in the harassment restraining order that says that a minor can file against on their own against a spouse or former spouse or someone they have a child in common with. That language doesn't exist in the HRO statute. So just like in orders for protection, we have ex parte harassment restraining orders and final harassment restraining orders. So again, ex parte means by one party without notice to the other. To be able to get an ex parte, you have to allege immediate and present danger of harassment. And just like orders for protection, ex parte harassment restraining order can become final if a hearing is not requested by either party. You have a final order either after agreement or after an evidentiary hearing, or if it becomes final because nobody asked for that hearing. What does one file? You file a petition and an affidavit for ex parte relief. Again, you don't need the respondent's address for the court to issue the ex parte. And then there's the law enforcement sheet. So those would be the things that get filed. Oh, I thought I fixed this, so I didn't have such tiny words. Sorry. How to file a harassment restraining order. So you take all the paperwork, and again, in every county but Hennepin, you would present it to court administration, or if you're doing it through guide and file, you would do it through guide and file. It's then given to the judge, and if it is signed, it's given to law enforcement for service. If you are in Hennepin and you're working and you are a community-based advocate, it's often faxed to the signing judge of the day, and then if signed, given to law enforcement for service. If you are not working, if the person is not working with a community-based advocate, they would go through self-help to be able to file that harassment restraining order. So orders for protection go through the Domestic Abuse Service Center, or called DASC in Hennepin County, harassment restraining orders through self-help center. There are fees for harassment restraining orders for both the petitioner and the respondent. There is a $285 fee plus county specific law library fees, which vary from like $5 to $20. So it depends on your county. Or somebody could file for what's called informa pauperis or fee waiver. So this is where if you're receiving government benefits, or you're under 200% of poverty, you can ask for the fees to be waived. So you can always file for that if either the petitioner or the respondent can file. However, according to our statute, which is actually required again by federal law, the fee is waived if the petition alleges a violation of the stalking statute, subdivisions 2, 3, 4, or 5, which is harassment, aggravated harassment, or stalking, or the petition alleges criminal sexual conduct 1st through the 5th degrees. Now, again, almost all the folks that we would be working with as domestic or sexual violence advocates should qualify for fee waiver. So it would be an unusual circumstance as it relates to the folks we work with, that they wouldn't qualify for fee waiver. How long does the harassment restraining order last? The statute says it can be 2 years, up to 2 years. It can be shorter. It can't be longer. That language is not in the statute that allows it to be longer than 2 years, unless they qualify for a 50-year harassment restraining order. And again, we'll talk about the specifics of that when we get to extensions. What are the timelines for service? Harassment restraining orders have no specific timeline for service. However, as we kind of talked earlier, it's not enforceable until it is served. So it's one of the interesting things. You could have a harassment restraining order issued for 2 years and it take a year for service. The order is valid that whole time. It's just not enforceable. Once it gets served, it could be enforced. But you have to worry less about the timelines of making sure you know whether or not it's been served, because it's not going to expire, unlike an order for protection, which will expire if it's not served within 14 days. Once served, a hearing has to be requested within 20 days of the harassment restraining order being served and by the respondent. Service by alternative means is not available in harassment restraining orders, so service has to be done by publication. And that is only when service is unsuccessful because the respondent is avoiding service by concealment or otherwise, and a copy of the petition and the order for hearing and any temporary order has been mailed to the respondent's residence. Okay. Differences between an OFP and an HRO. An OFP is a family court order, and you need to show domestic abuse has occurred with a special relationship of that family or household member, and the relief is broad and includes all sorts of things. Harassment restraining order is a civil order. No special relationship is needed. You got to show harassment occurred, and the relief is only no harassment and no contact. All right. What questions do folks have before we move on to writing the affidavit? Okay. All right. Not seeing any. Oop, never mind.
I have one.
Yeah.
Can you ask for an extension of an OFP after the OFP expired?
Yes, you can. And we'll talk about extensions in a minute. So,
Okay.
but yes, you can. And then it looks like somebody put in the chat, why are so many just being dismissed without a hearing? And if we're talking about harassment restraining orders, that's, I guess the court is deeming them to not have any validity. We know that that's an issue. I've been talking with court folks around some of these concerns. Please continue to talk to Standpoint when these things are happening to try to figure out options that might be available to you. Can you file an OFP in Minnesota if respondent lives in a different state? Yep, you can. Yep. So remember, you can file if they live in another state. You just have to show that they're the contacts that exist. We talked about that in a slide before. And then is the court fee due when filing an OFP HRO if after the hearing? There are no court fees for OFPs, so you don't have to worry about that. And if the person doesn't qualify for fee waiver or doesn't qualify to have the fee waived because of what they're alleging in their petition, you have to file the court fee before. You have to file as you're filing all of your paperwork. Otherwise, the court won't move forward without that. Do you file an IFP affidavit to ask for fee waiver due to 609.749? No, you should. It's based on what's in your petition, or it's supposed to be based on what's in your petition. Again, 87 different county courts doing 87 different things, but that's what's supposed to happen. All right. Questions? Okay, so writing the affidavit. So when you're working on the affidavit for whether it's an order for protection or a harassment restraining order, you want to make sure that you are keeping in mind that standard the court is going to apply. So it's that initial order of protection, harassment restraining order. You need to show that domestic abuse or harassment has occurred against the petitioner. And that's true even if that order is on behalf of a child, right? Remembering that an overt act is not necessary, and the totality of the circumstances is what the court's going to look at. But you need to make sure that you're showing that domestic abuse or harassment occurred, depending on what kind of order you're applying for. When you're writing the affidavit, you want to include the date or the dates that the incidents happen. If the specific date is not available, saying something like the month or the season or the year, you want to state where the abuse or the harassment occurred. It happened in the living room or it happened at the bus stop. Want to state what part of the body the abuser or harasser touched, if anything, face or arm or leg. State what part of the abuser's body was used, if any. So this isn't like a physical incident. Did they use their hand, their fist, their foot? If threats were made, use the exact words and place those words in quotes. Describe any gestures such as a raised fist, a flushed face, especially any gestures that have particular meaning and for the petitioner and why those gestures make them afraid, right? It's really, really important to explain to the court why the petitioner was afraid and how they felt afraid. If they were afraid, what were they afraid of? Simply saying, I'm afraid of the respondent. Cool. What are you afraid of? You're afraid they're gonna take you to court and get custody? Not a reason to get an order for protection. It's a good thing to be afraid of, but you're not in fear, imminent fear of your physical safety. That's what ex parte order for protections are trying to get at. Or you're not in fear of imminent harassment. That's what a harassment restraining order is trying to get at. So what are they scared of? Scared they're going to be hit, kicked, prevent from leaving. They're going to be further harassed. What are they afraid of? State how loud the abuser's voice was, how long the incident lasted. Was there anybody else who was present during those incidences? So for example, the first is not the greatest example of writing for an order for protection. Respondent's been calling my house saying he is going to make me sorry for making him pay child support. I'm afraid of what he's going to do. All right. So a better example would be on February 15th, 2023, the respondent called my house for the third time in a week. He was very angry. He was yelling at me. He told me, I am going to be sorry. He said that he's not going to pay any effing child support. The respondent also told me to back off. I'm concerned for my safety because when I lived with the respondent back in 2022, he threw plates at me, he kicked our dog, and raised his fist at me when he was angry. The respondent has also told me that he would find me and hurt me if I ever sought child support from him. I am now afraid that he will make good on his threats to harm me. Right? So you can see how the second example, not all that much longer, but provides the court a much better understanding of why she's afraid he's going to why she's afraid of him, and why this child support piece is a trigger, right? So now the court has a better idea of, oh, I get it, I see, and if I have any understanding of domestic violence, I really see how this could be a scary situation. And the petitioner is saying, I'm afraid he's going to hurt me, right? So now we understand why there is a fear of imminent physical harm, right? Harassment, an example of a harassment restraining order. I actually had this example is what was said in a case that went up to the Minnesota Court of Appeals that I represented on. Inconsistently follows me and drives constantly down my street. Parks on the opposite side of the street and or drives through development, November 17th or October 17th through November 4th. It was amazing that her order was granted. However, it was, which is then why we ended up at the Court of Appeals. But so better and explaining better about what was happening in this situation was, since October 17th through November 4th, the respondent has driven past my house about 5 times a week. I live in a housing development and the respondent does not have a reason to be in my neighborhood. About twice a week, the respondent will park across the street from my house and stay there for about an hour and then leave. In this time period, the respondent has followed me when I was in my car 3 separate times. He has followed me from my work all the way to my home. When I pull into my driveway, the respondent then speeds away. This behavior is scaring me and I want the respondent to leave me alone. Right? So it's describing that the harassing behavior that is occurring in much more detail. It doesn't take a lot more lines to explain, but it gives the court a much better idea what's happening. And we can also understand how this is affecting the petitioner's safety, security, or privacy, right? It's scaring them, which is affecting their safety, right? So making sure to have clearer examples and being specific with the court is really helpful. So when requesting relief, you want to think carefully about what relief is being requested. And that's also part of being thoughtful about, do we need to is this an order for protection situation, or is this a harassment restraining order situation, if the person would qualify for either one? Being very thoughtful about what kind of relief you're going to be requesting. And if you're going to be asking if the petitioner wants to ask for supervised parenting time or supervised exchanges, you need to help that person figure out, how is this going to happen? You've got to have a plan. And I can tell you, when I've watched judges or talked to judges or other judicial officers, if you have a plan, if you're like, I've already talked to my mom and my mom is willing to supervise that parenting time, or my mom is willing to do those exchanges, the court is much more likely to accept your plan and to go with the relief you're asking for if there is a clear pathway. If you're like, I don't know how this would happen, it makes the court and the respondent clearly isn't likely to want to make suggestions, or if they do, it's going to be somebody who the petitioner does not want to be the one supervising the exchanges or the parenting time. And you don't want the court to start hesitating and then just be like, forget it, I'm not going to do it at all. All right. So make sure you have a plan if you're requesting supervised parenting time or exchanges. All right. So what is this court process going to look like? So once you file and if you end up and you're going to have a hearing, there is, like I said, for a lot of courts, and the thing is we have 87 counties in Minnesota, and while the Minnesota Supreme Court can make suggestions to the district courts about how to handle their cases, the truth is they can't make them do anything. So you have 87 counties doing it 87 different ways, and then even each judge in each county may be doing it differently. So some counties may have the evidentiary hearing is going to happen at that first hearing. Some counties, that's not true. So it's important for you as an advocate to get to know your county or counties, if you have more than one, and find out how they do it. It's your job to figure out how your individual judge does it within your counties, because that may be different. The folks who are working with you, the victim survivors who work with you, that's one of the things they're really looking for from you to be able to help them understand. But for some hearings, most hearings, the court is in the beginning going to ask if the respondent would like to admit or deny the harassment or the domestic abuse. And so they'll say, do you admit to the allegations in the petition and then agree to the issuance of this order? Do you deny the allegations in this petition? However, you are willing to agree to the order. Or do you deny the allegations and you want a hearing? And then you go to an evidentiary. In Hennepin County, if it's a harassment restraining order that's saying you want a hearing, may lead to mediation on the harassment restraining order. So just be prepared and aware that that's a possibility. If there is an evidentiary hearing, normally the petitioner testifies first, the respondent gets to cross-examine the petitioner. The petitioner would call their witnesses. If there are any, there would be cross-examination of those witnesses. Then the respondent would testify. Petitioner gets to cross-examine the respondent, and then the respondent would call their witnesses, and there would be cross-examination of the respondent witnesses. So kind of that back and forth if folks are not represented. When helping prepare the petitioner for being able to provide testimony at an evidentiary hearing, things to think about and to help the petitioner think through. If the petitioner is alleging they've been physically harmed, they want to describe the most recent incident of physical harm. What was the date, approximate time, or the season, or the whatever it's going to be, getting as close as possible. You want to describe the assault and the threatening behavior, helping the petitioner realize to not dwell on the events leading up to the assault. Of course, when you work with domestic violence victims, they'll tell you that, I've had plenty of victims say, if all they ever did was hit me, I would have left years ago. Right? It's not the physical abuse that's the most devastating to most victims. It's all that emotional abuse and the financial abuse and that kind of stuff. However, super important to the victim and super important for us. The court is bound by what the statute says, and that emotional and financial abuse is not part of our definition of domestic abuse. So we want to get to the part about the physical abuse or whatever the basis of the order is, as opposed to dwelling on the events that led up to it. Use specific terminology. Don't just state conclusions. Don't just say, just don't say he beat me up. Say he hit me at least 10 times in the face and the left shoulder. He hit me with his right fist, which wore a ring, and it cut my upper lip on the side. Being, again, as specific as possible as the person remembers. Again, stating the number of times the abuser hit, kick, slap, push. If there were children involved or hurt in any way, state how. And then describe the results of that assault. What were there cuts or bruises, internal injuries? What happened? Were those injuries treated? If so, where, by who, and when? Were there photographs that were taken? And then do you want to submit those photographs as evidence? Did anyone witness the treatment or the injuries? Were law enforcement called? Was there a police report? Was the abuser arrested? Are there criminal charges? Did the petitioner leave the home? Where did they go? Was there any job loss or property loss during the assault or as a result of the assault? So talking about all the results that could have came from that assault. If the petitioner is primarily moving for an order for protection based on imminent fear, what were the specific actions that made them fear harm? What did the abuser say or do? And again, being specific and saying why, right? So the abuser came home carrying flowers. Okay, cool. That's probably not scary for most people, but it's scary for this victim. Why? Well, it is scary to me because my abuser said if he ever came home carrying flowers, those flowers were going to be on my gravestone. Okay, so what's the part that makes them afraid? Why are they scared? When did this occur? Date and time. Describe their demeanor. Were they flushed-faced? Were they angry in their voice? Were they shouting? And again, what is the petitioner afraid the abuser is going to do? And why do they have that fear? What has happened in the past that has made them have that fear, that's what they're going to do. Okay. Petitioner's testimony, if it's a harassment restraining order, again, it's very similar. So date and time, how many times a week, a month, is this behavior happening, especially if we're talking about multiple incidences that are interfering with safety, security, or privacy. How often is this happening? Where is the harassment occurring? If there's threats that are being made, what are those exact words? Describing those gestures, and stating how they felt, including if it's having a substantial adverse effect on them, and what is it? They probably don't want to use that specific language because then it might sound coached. But they do need to explain, like, this is scaring me, and it's scaring me because of XYZ. These are the things that I have done to protect myself. I used to sleep with my windows open, and now I am so afraid I sleep with my windows closed, and I lock them, and I never want to open them no matter how warm it is outside. And I don't have air conditioning, but I'm too afraid to open my windows. Okay, so this is having a significant effect on somebody's safety, security, or privacy. So explaining how they felt and what they are doing in result to how they feel. State how loud the harasser's voice was, how long the incident lasted, and who else might have been present during those incidences. Okay, so after this hearing, you go through, have an evidentiary hearing, or the order for protection or harassment restraining order issues as ex parte, and there is no hearing, it becomes a final order. What are the things that you want to think about after the hearing? All right, so if you have an actual evidentiary hearing, it's really important to do something called, and the court grants the order for protection or harassment restraining order. It is important to do what's called a notice of entry of order. And the reason is it starts the appellate time clock ticking. You have 60 days from the issuance of the court ordering the OFP or the HRO to appeal. If you never do a notice of entry of that order, the time clock never starts ticking. And that actually is what happened in the Petrovnik case. There in the Dropbox, there is instructions on how to do it and a sample that you can follow. So I'm not going to spend a bunch of time here today because I got 10 minutes on that, but there's instructions and examples. And of course, please call Standpoint if you have questions. So you can extend or get a subsequent order for protection if your order for first initial one was granted. There is, for 4 reasons, you could get an extension or a subsequent order. If the respondent has violated a prior or existing order for protection, and Upman v. Miller says that violation does not need to be a conviction. It doesn't need to be criminal charges. You just need to be able to show the court by preponderance of the evidence that a violation occurred. The second reason is the respondent is in a reasonable fear of physical harm from the respondent. The petitioner is in reasonable fear. And that's a much lower standard, right? I don't need to show imminent fear here. I just need to show reasonable fear. The respondent has engaged in acts of harassment or stalking, or the respondent's incarcerated and about to be released or has been recently released from incarceration. So comply to extend or get a subsequent. So extending would be an order that currently exists. A subsequent order would be the order has lapsed. Often happens when somebody is incarcerated because there's may not be a reason, or things quieted down for a while, the order lapses, and now all of a sudden something's happened and there's again scary behavior or harassing behavior that's happening. And so, or something that's going to make them concerned that that behavior is going to happen. And so a reason to seek another or a subsequent order for protection. If the petitioner only seeks relief under sub 7, so that remember that specific relief that you could get an order for protection for without a hearing being triggered, then no hearing is required unless the court declines to issue the extension or subsequent, or the respondent asks for a hearing. So the respondent can always ask for a hearing. That's for an order for protection. There is no ability to extend a harassment restraining order. There is no statutory language for it. And we have Rower v. Dunham that specifically says you cannot extend a harassment restraining order. You have to have new and recent incidences of harassment. So. For 50-year orders, both the order for protection and the harassment restraining order statute allow for 50-year orders. And that is when one of two things have occurred. Either the respondent has violated a prior or existing order on 2 or more occasions, or the petitioner has had 2 or more orders in effect against the same respondent. So you may have gotten you may have one order for protection and the respondent has violated it 2 or more times. Petitioner can seek a 50-year order. Or they had an order for protection and then extended that order for protection. Now they've had 2. The next time, now they can come and seek a 50-year order for protection. It does have to be the same kind of order. So if you have 2 or more, it's got to be 2 or more orders for protection against the same respondent, or 2 or more harassment restraining orders against the same respondent. You can't have a harassment restraining order and an order for protection and then get a 50-year. Got to have 2 of the same kind. Technically, the relief under the statute is only no acts of abuse or harassment and no contact. However, I've seen lots of 50-year orders. Well, lots is a strong word because there just aren't that many of them, period. But I have seen 50-year orders that grant a lot more relief than that for the domestic abuse for an order. '50-year orders can be vacated or modified by the respondent after 5 years and there have been no violations. However, the statute tells us that burden is upon the respondent by preponderance of the evidence to show a material change. So the respondent not only has to show that there's been no violations within those 5 years, but also that there's some sort of material change and a reason why this order needs to be lifted beyond just, I don't like it. Be a good reason. For modifying, for the order protection statute has has language. Harassment restraining order statute does not. But the order for protection statute says to modify, you file a motion with an affidavit and you have to have a hearing to do a modification. The statute also says that the no abuse provision, the provision that says that you won't commit further acts of domestic abuse, cannot be vacated or modified in a divorce proceeding, period. And that there has to be if there's going to be a hearing for modifying the order for protection, that there within the divorce proceeding, there has to be a notice of motion and motion. That notice can't be waived. And there has to be a separate order that needs to issue. So you just can't do it all in one big clump without doing, because they're 2 separate court orders, they're 2 separate court files, there's process that has to be followed. For dismissal, neither the order for protection nor the harassment restraining order outside of the 50-year order talk about how dismissal is supposed to work. So it is the petitioner's order, and so the petitioner gets the choice to dismiss it if they so choose. And so normally it's by filing a motion for dismissal. And then how that happens at the district court level kind of varies between courts. Sometimes the court will some courts will just dismiss it upon receiving that request for dismissal. Some courts do schedule a hearing where the petitioner needs to come in and talk with the judge. Sometimes the respondent's present, sometimes they're not. It really depends on your community and your court on how your judges handle that. As it relates for the respondent requesting that the order be dismissed, there's no ability to do that unless it's that 50-year order. There's no statutory authority for it. If you had a hearing, well, you have an opportunity to ask for that hearing. If you lose as the respondent at that hearing, you can't go back and then ask the court to dismiss it. It would be no different than going to through a civil trial, getting a financial monetary award, and then coming back a couple of years later and being like, I don't really like this financial award. I want you to dismiss it. It doesn't work that way in the civil world. It doesn't work that way in the protective order world. So the respondent just has to wait until it either expires or the petitioner decides to dismiss it. Other things to think about. The courts are not supposed to be issuing mutual orders of protection or harassment restraining orders unless both parties file a petition. And so there's case law that says that you gotta have both parties file and ask, and the court has to make a finding that domestic abuse or harassment occurred by both parties. Unless you agree to it. You can agree to anything. Just always remember, you can always agree. But if one party is objecting, then that's the process the court would have to follow. Any testimony that's offered by the respondent in an order for protection is inadmissible in a criminal proceeding. This is not true for the petitioner. Okay, so if you were working with a petitioner who is also a defendant in a criminal case, anything they say as a petitioner in an order for protection is admissible in a criminal proceeding. This is also not true for harassment restraining orders for either the respondent or the petitioner. There's no cover. But for somebody who is a respondent in an order for protection, anything they say is inadmissible in a criminal proceeding, in the order for protection proceeding, inadmissible criminal proceeding. Other things to note. In awarding custody or parenting time in an OFP, the primary consideration is to be the safety of the victim or the children. So it is also, the court is supposed to be considering the safety of the victim, not just the safety of the children. And again, if you're going to ask for supervised parenting time or exchanges, how is that going to happen? All right. And then finally, domestic abuse no contact orders. So domestic abuse no contact orders are issued in criminal proceedings, and they are against the defendant for when when the defendant has been charged with domestic abuse as defined under the statute, harassment or stalking against a family or household member, a violation of an order of protection, or a violation of a DANCO. And I love very much that you can get a DANCO for violating a DANCO. So there's already one there. You get multiple DANCOs. That's the next case. So the court that's when the court can issue them. And they are issued either pre-trial or post-conviction. It is not a condition of release. And they are issued in a separate proceeding immediately following any pre-trial release or sentencing. So DANCOs are an option in criminal cases. It is the prosecutor who seeks them, and the victim may or may not have much say, depending on your community, about whether they are granted or whether they continue. And that can be very difficult for a lot of victims who may not want this order in place. Okay. So I have a quick summary of the differences between OFPs, HROs, and DANCOs. All right, so orders for protection are issued out of 518B. They are a family court order, and you have to allege domestic abuse has occurred, and that's one of 6 things. Harassment restraining orders are issued out of 609.748, and they are civil orders, and you have to allege that harassment occurred, and again, it's just one of 6 things. DANCOs are at a 629.75, and they are a criminal order, and they're issued in cases where criminal charges are pending or a conviction for domestic abuse, harassment or stalking against a family or household member, violation of an OFP, or violation of a DANCO. OFPs, you got to have that special relationship of a family or household member, and you can get broad relief, including that whole other category. Harassment restraining orders, you do not need a special relationship. You get one against anyone, but your only relief is very narrow. It's only no contact and no harassment. Domestic abuse, no contact orders. Again, you need to have that special relationship of family or household member, and your only relief is no contact. And then finally, there are no fees for an order for protection for either the petitioner or the respondent. It is the victim who seeks the order for protection. There are some very strict timelines for hearings, and things to keep in mind is even if the order for protection is dismissed, there still could be a domestic abuse no contact order. Harassment restraining orders, there is no fee if the petition alleges a violation of 609.749 or the criminal sexual conduct statutes. Otherwise, there is a fee. It is the victim who seeks the order. There are no timelines around hearings. And remember, even if there is an HRO that's dismissed, there still could be a DANCO or some other criminal no contact order that might exist. And finally, in the DANCO, there is no fee. It's the prosecutor who seeks it. It can only happen in a proceeding in which pretrial release or sentencing issues are decided. And even if the DANCO is dismissed, there still could be an OFP or an HRO, and the family court cannot modify a DANCO. The criminal court has to do that. Okay. I know that technically we're 3 minutes over, but I'm taking my, we started a little late, so I'm totally gonna take that time. Can't stop me. So questions. I see that Robin has asked, how much time does a respondent have to request a hearing in the subsequent OFP? It's going to be the same. They have 5 days. It's going to follow all those same rules as requesting a hearing as in an initial order. What other questions? What's the purpose of ordering a second DANCO when the first DANCO gets violated? We have another case that's pending. And so if the first case that has the DANCO on it resolves in some way and the DANCO goes away, now you have a second one. So that's the best reason to have them. And technically there are multiple charges, but that's not going to happen. It's the fact that if the first case is resolved, then you have a second. The idea of getting the victim to state the incidences in more detail on the affidavit and at the hearing is a great idea, but it's so hard for them. Yep, it absolutely is hard. And if that's not something that is comfortable, then maybe the order of protection is, or harassment restraining order is not the best option for them. The court's going to need enough information to be able to issue the order, and specificity helps them know that there is enough there. It also, when you're talking about credibility of somebody, folks believe when you are more specific that you're more credible. So it's another reason why specificity is important. And that's help that advocacy can really do with that victim, is helping them write down what are the things that they want to talk about, and helping them think through and rehearsing it and being prepared. And sometimes all that rehearsing and everything goes out the window when someone gets on the stand. It happens for sure. Can a judge keep a DANCO in place even if the victim does not want it? Absolutely, they can, and they do. It is listed. Per our statute, as it relates to domestic abuse no contact orders, it is not up to the victim whether or not they want, whether or not there's a DANCO. The DANCO is useful, is a tool by prosecution to try to prevent any sort of victim intimidation that might occur while they are prosecuting a defendant for the crimes that are listed. Do prosecutors ever consult the victim before requesting the DANCO? A lot of prosecutors do, or they'll do that through their victim witness advocate sometimes. So a lot do, some don't, and some may consult and take their wishes into consideration, and some may decide, I'm not that, yep, I hear what the victim doesn't want this, but I feel like for whatever their reasons are, that they're gonna ask for the DANCO anyway, over the objections of the victim. So that's up to the prosecutor gets to make that call. And sometimes they do, and sometimes they don't. Guys, I want to be respectful of everybody's time, including our lovely, amazing interpreters. I want to thank you all so very much for attending this training. Like I said, there will be another training with that's more specific. Hopefully it's going to be hosted by Anna Maria and Maddie and Raylene in the coming months. So look for that. Sorry. I would like to thank our interpreters. Thank you both so very much for providing this awesome service. And thank you all. And I hope everybody has a wonderful and lovely rest of your day. And remember, Standpoint is here to support you. Please use us. It is why we exist. It is what we get paid to do, is to support you. So please remember, you're never bothering us. We're here to support you. Thank you all so very much. Have a great rest of your day.
Thank you, everybody. Hope to see you next month.